How do Miranda rights work in the Muscogee Creek Nation? My name is Ted Hassey. I'm an attorney practicing in federal and tribal courts in the state of Oklahoma. This is third in a series of questions that were submitted to me here asking about Miranda rights. Let me just talk briefly about what those are. Most people are aware of what Miranda rights are and what they sound like. You have the right to remain silent. Anything you say or do can and will be used against you in a court of law. You have a right to an attorney, et cetera, et cetera. Usually, law enforcement officers will read those Miranda rights to a defendant before engaging in interrogation. And the reason that they will do that is because if there is a custodial interrogation that happens in a U.S. jurisdiction like, well, really any state jurisdiction, certainly federally, if it comes before the court that a custodial interrogation happens without those warnings having been provided to the defendant, it's possible and sometimes likely that any statements they make that could be used against them, any statements that were unfavorable, any confession in a custodial interrogation without those warnings can often be kept out at trial and be excluded as evidence. Now, with regard to Muscogee Creek Nation, other tribal courts, it's trickier. Now, I don't want to go too into the weeds on this. For the most part, people's rights, the same rights that one would have under the U.S. Constitution and through the Bill of Rights, apply to defendants in tribal court too, but through another mechanism. And furthermore, in many instances, it is not required necessarily that a tribal court judge follow the precedent of the U.S. Supreme Court. Now, the U.S. Supreme Court has been clear on Miranda. However, there have been sort of changes along the way. The long and short of it is that it hasn't been addressed directly by the Muscogee Creek Nation Supreme Court, and so we don't know for sure if it were heavily litigated, if there were a major issue, how this would necessarily come out. In practice, though, what I've found is judges in the Muscogee Creek Nation are very interested in protecting the due process rights of defendants. That these judges tend to be persuaded by authorities outside of their jurisdiction, like the U.S. Supreme Court and federal courts, where it's reasonable. And were I in a circumstance with a defendant who perhaps had his rights violated in this way, a custodial interrogation without warnings, I would expect that it would be likely that a judge would be very open to considering holding out and excluding an improper confession. So that is to say, the technical answer is it depends, and it's complicated applying Miranda rights in a tribal context. Practically speaking, though, folks seem to be interested in protecting the rights of defendants such that an improper interrogation there's a really good chance we're going to get thrown out of court. If you or a loved one is facing legal challenges in Muscogee Creek Nation, other tribal courts, or federal court, be happy to talk about how we can help you. We can be reached at 918-932-2800. Again, my name is Ted Hassey.